We're live.
Welcome back, everyone, to House General and Finance, and it is still Thursday, February 5th. And we've been working on landlord-tenant issues. We have 5 bills before us. We've just spent several hours yesterday and today going through side by side and attempting a first pass at reaching an understanding on civil procedure as it relates to landlord-tenant issues. And now we're going to start testimony on these bills or on the issue generally. And our first testimony is from the Champlain Valley Office of Economic Opportunity. And would you identify yourself for the record, each of you, and take it away?
Good morning. Thank you so much for the opportunity to be here today. I'm Jess Hyman. I'm the Associate Director of CVOEO's statewide housing advocacy programs. And I'm here today to provide support to Karen Ames, who will be doing the primary testimony, and I'll also be answering questions.
So Karen Ames, Housing Education Coordinator for the Vermont Tenants Program, and that is part of CVOEO and part of the Housing Advocacy Program.
Vermont,
I'll explain that.
what program?
Tenants.
Yeah.
Take it away.
All right, so thanks so much for having us. It's really, we really appreciate the chance to speak, to share information. Also, I want to mention up front that there is a lot contained in these bills, as you've been taking in, I'm sure you realize, and we're happy to come back and answer specific questions as you move through this process. Because I'm not going to get into like this language in this bill and that kind of thing. It's just more general what we support and let you know what our experiences are working with tenants. So CVOEO, as my colleague Kalia, who was here last week, mentioned, is one of the community action agencies around the state. So primarily our programs are offered to the Champlain Valley. So that's Franklin, Grand Isle counties, Chittenden County, and Addison County. However, our housing advocacy programs are statewide, and we do serve people statewide. So the statewide programs consist of six programs, but primarily the largest 3 are the mobile home program, which serves folks who live in mobile home parks. So those are people who own their homes but rent their lots. And the resident organizing, education, that kind of thing. And then the Fair Housing Project, which Jess leads, is also statewide, and they provide individual consultations and trainings for tenants, landlords, and municipalities. My program that I work primarily with is called the Vermont Tenants Program. It's been around since the 1980s. Sometime between the 1980s and now, quite a while ago, we started offering a hotline. And that is a service that does get utilized statewide and is pretty well known in the communities. We get a lot of referrals from a wide variety of partners explaining the service to their tenants. We get a lot of calls from tenants. We also provide educational materials, which is referenced in Chair Mahali's bill, the Preferred Renters Program, which includes housing, education, tenants' rights, responsibilities, fair housing, as well as finding housing resources, how to overcome barriers, how to develop a relationship with the landlord, that kind of thing. And then basic finances, building a budget, repairing credit, how to manage your money so you can always pay the rent. And that program also includes a one-on-one coaching experience with a financial coach. Uptick in that program has really increased in the last couple of years as people struggle to find housing and need more resources and want to be more competitive in the market. All of our programs through Vermont Tenant are offered through a problem-solving approach. So the first thing I cover the hotline sometimes when my colleague Madeline is away, and the examples that I'm going to provide are mostly through the hotline or individual consultations. We approach it with a problem-solving approach. The first question I ask a tenant is, have you talked to your landlord? And very often that answer is no, for a variety of reasons. They feel bad about being behind the rent. They feel bad about something that's happened. They're unsure, or they're intimidated. They don't want to speak up often if they're complaining about conditions because they're worried about losing their housing. So there's a whole variety of answers, but that's where we start is the tenant landlord is a relationship. And we want both people to thrive in that relationship. So it's all about, as one landlord put it to me, where can you find the win-win, in the situation? So the topics that I want to touch base on today, and I know you guys like asking questions, and I prefer to stop and answer questions along the way. So whenever
That will happen.
ask the question.
Fear not.
Excellent. That's my preferred mode. So these are the key topics that I do want to touch on today in some part. So if we get sidetracked on one topic, I might ask that we come back to that if we can. But also I'm here to make sure that if you have questions, you get them answered.
I'm sorry.
Yeah.
As you were speaking, I just wrote down a question, but I figured I could probably just ask, do you know if right now in current state statute, there's language that protects tenants from retaliation? So if
There is.
okay,
There is. And there's a specific line, I can't quote you, that's okay. I'm glad you asked that. It prevents retaliation. I forgot the legal term, but it's not a lawyer. But it is something along the lines of there's presumed retaliation if an action is taken within 90 days of a tenant filing a complaint or organizing a tenant organization or something like that.
so that would be for an action taken by a tenant. So if a tenant goes to their landlord and says, hey, my water heater is busted.
Yeah.
And then the next day, the landlord sends them an eviction, that
That's
wouldn't be
retaliation.
covered.
That would be covered.
It
Yeah.
would be covered.
They would have to make that case.
Okay. Okay, but it's not, it doesn't have to be an official complaint or anything. It's just like a.
No.
Okay, thank you.
That's my understanding.
Okay,
But I'd have to read that statute. That's a good question.
I'll ask again.
Council.
Yeah. thank you.
And I'm glad you brought up that question because it does bring something that I do want to mention somewhere, and then we'll get back to this.
Sorry.
I can get sidetracked and talk housing all day, so I've been primed to stick to the topic. But we are not lawyers, but we do help people understand the law and make referrals when necessary, which is often to legal supports or social services or whatever their needs are, financial counseling, whatever it is. The more clear you can be in your language in the law, the better it is, not only for the tenant and the landlord, but for anybody in between and who's assisting folks. Right now, some things are super, super clear. Landlord access, cut and dry, it's pretty clear. Anything that is reasonable or nominal or, some of these terms, anything that you can do to specify would be helpful. So that's just a comment about language on the bill. So to get back, we do not support eviction, shortening eviction notice periods. I have a couple of examples to explain why. And I believe that we have some understanding about what's behind that, but the essence of what will happen is more unhoused people in Vermont. And that's already happening at a pretty high rate. We don't want to increase that. We do support rent increase limits. This will support all people in Vermont, working families as well as those who are really struggling. We support just cause eviction protections. For the example that you just had, if someone complains to the landlord and they've gone through their first year lease or they've just always been month to month, even if the landlord could give them a no cause termination with appropriate termination and not cite that it's because they complained, but they could just do it because it's available.
On the just cause evictions, how many cases in Vermont have been for just cause and nothing else?
Just you mean for cause or for no cause?
Well, you have just cause.
That's the
eviction.
terminology that's used. The two ways of, as you know, I think, there's no cause and for cause.
Right, so are you talking about a for cause?
I am saying there should be For cause, yes.
Okay, so how many, well, in today's law, when we have the no cause.
Yes.
In today, how many, cases have been brought to court with just for a no cause eviction, nothing else is filed?
Right. Later this afternoon, I believe Jean Murray with Vermont Legal Aid is going to be here and she has great
Okay.
statistics. So I'll refer you to that. My
Yes.
understanding is as of last year, the best numbers that are available are about 20% are no cause. That's an understatement because those terminations don't go to court, right? Unless the tenant stays after the termination date. So it's a very hard number to get a handle on. And that actually, I'll jump ahead. One of the things we support strongly is a rental registry. Sorry, I touched that. Rental registry. And one of the problems with discussing these matters is data is hard to find. It's hard to really nail down because we don't have a clear idea of exactly who's renting in Vermont and, who our landlords are and whatnot. So that would be a good plug for a rental registry. Jess can speak to that a little bit more clearly. Does that help?
The rental registry?
No, I'm sorry, to answer your question.
Yeah, well, I made a
Okay.
note.
Okay, yeah, she's full of information. She will definitely be able to answer that question real well. We support clarification of application fees because there was a change made last year and I believe that the intent historically in Vermont has been application fees are prohibited, period. And what has happened is this practice of charging for background checks and credit checks has sort of crept in. And then, well, I'm sorry, this is supposed to be the overview. And then more fees are being charged over the last few years. So I'll explain that in just a minute. And then we also support the rental registry, a tenant right to counsel during eviction proceedings, record confidentiality, and there's some appropriations that Jess will speak to at the end. We submitted a written testimony that has lots of detail on all this. So I'll refer you to that if I'm being too vague as we go through. So I want to start first with eviction notice periods with two examples to show you the impracticality of shortening those notice periods. So the first example I'll call Alice, I've tried to anonymize these, is a call I took on the hotline last November. And Alice is a first-year nursing student. And she was working full-time, then started her nursing program and realized she couldn't keep up full-time with her nursing program and working. So she cut her hours a little bit and then received her tuition and books and all that bill. She prioritized paying all that, the tuition and books, got behind on her rent. So by the time she called me, she was 7 days into her 21 days to respond to an answer and forth. So it took her 7 days to figure out how to even get to the person to ask for help. Then I asked her, of course, to call Vermont Legal Aid right away. They're backed up. So I knew she wouldn't get an answer, ASAP. But fortunately, they have a great website. I don't know if you've browsed it, but Vermont Law Help, excellent resources. They have a form letter that folks can use to provide the correct format because they can't just write a letter. It's got to be a correct format to respond to court. So I was able to guide her through that process, refer her to Vermont Legal Aid, refer her to my colleagues who do housing retention and support. They were able to work with her to apply to the landlord relief program. And this case ends in a happy ending. She was approved and got some support for that back rent and made a budget and was able to move forward in a sustainable way. That took time. It takes time to contact resources. It takes time to contact Vermont Legal Aid. It takes time to apply for the back rent. If you're doing it through a HOT program, it takes time. I know that because we do that work at CDOEO. So that's one example. The second example I'll talk about is Jenna. Sorry, I need to drink water. And not everybody is as positioned to provide for themselves and help themselves as Alice was. So Jenna called me on a Thursday, I remember this, through the hotline, and she had to file her answer in court by Monday. She had in a timely manner called Vermont Legal Aid and had been waiting for a call back because she didn't understand that she wouldn't get a call back right away. So by the time she asked around and found resources and called me, she had 4 days. Jenna is a single mom and she lives in a rural part of the state. She does not have transportation. So she depends on friends and family to get around. And she has 2 young daughters who are in school. Fortunately for Jenna, she lives in walking distance, real nearby a library. She has a relationship with the librarian. So I was able to, what she said to me on the phone was, I'm terrified of living in a tent with my kids, of being on the street with my kids, because I have a friend who had to do that. So I urge her to call Vermont Legal Aid back and tell her exactly what county she was in and, prioritize this help. Meanwhile, I walked her through the process of filing an answer herself. She was going to go the next day and work with the librarian to do that, to print it out. And then we problem solved getting transportation on Monday. Where was the courthouse that she could get to, that she had to file this in, so that she could get there and file her answer in court. Jenna did disclose that she has a disability that makes her anxious, and this was partly why she had delayed as well. She could have, I did refer her to Fair Housing to ask for more time because she could ask for an accommodation due to her disability. But by the time the timing just would have been crazy. I don't know how that ended up. I did not hear back from her. So I'm hopeful that she filed her answer and that she also, I advise her to go to her local CAP agency and get some help with the back rent. So my point is that these timelines for everyday people are hard. And I can sit here and say, I know what to do. If I got a summons right now, I would file that answer, but I know the law, not every tenant is up on every bit of it. What I do want to say is that we have had conversations with nonprofits, landlords, and for-profit landlords, and have heard really heartbreaking stories about the intent behind the problem that is pushing that's behind the push to shorten the eviction periods. And so we understand, or what we've been hearing is that there's a very small slice of the tenant population that is causing a huge outsized problem, presenting dangers to their neighbors, conducting criminal activity, really heartbreaking things happening in housing situations. Very sympathetic to that. Their neighbors are calling us on the hotline too, right? The neighbors of the very problematic tenants. It's a very tough situation. I'm really sympathetic to that. What I would caution against is opening up tenant landlord law and eviction law and trying to solve that problem with what I consider kind of a blunt instrument to solve that problem. So when you open up tenant landlord law and you say a landlord can decide what's criminal, a landlord can just write an affidavit and decide, that opens it up. There may be landlords who are 100%, I know there are caring landlords who will bend over backwards for their tenants, who will really want to help their tenants and make good choices about that. There's also landlords who won't, just like there's tenants, all over the place we're all human, all over the place with their behavior. So I just caution you to be careful, because the way I have read those proposals, the bills, I can see how a landlord will use them not the way that you're intending in all likelihood. So I believe that Jean Murray will speak more clearly to that in terms of maybe some other options available. But if that's the intent, is to really get at real crime and dangerous situations, can we target that a different way without doing it through the landlord law?
Gail?
Oh, yes.
I have a question about what you had said earlier about confidential evictions.
Yes, confidentiality of eviction records. Yeah,
To whom? Confidential to whom?
let's jump and talk to that and I'll come back to rent increases. So, when someone, even though evictions are a civil violation or a civil record, they become part of someone's record, right? And it hangs around for life. So if you have a one-time, you lost your job, your car broke down, couldn't pay the rent, got into circumstances, but for the last 10 years, you've been great, that still shows up on your record. In this housing market, landlords don't want to deal with even hearing about someone with a problem in there. Eviction, that's all they hear. Eviction, person been evicted, done. Because they've got 30 other clients, potential tenants, ready to come in who don't have that on their record.
Right.
In addition to that, what's been happening recently, I had a call just in the last couple of weeks from a person, a tenant who had applied to a large nonprofit housing provider and been denied based on eviction. And his call was, how do I get this off my record? It's like, well, there's no way right now. But you've been evicted? Like, did you go to court? Oh, no, I've never been to court. Well, it turns out that he had he new to Vermont, moved into Vermont with the help of a partner organization in the community had agreed to pay the first 3 months rent, and then he was going to pick it up and move on. The partner agency must have lost funding. I don't know. They stopped paying after a month and a half. He didn't know that. So when the landlord sent a notice to vacate based on non-payment of rent, he went, yikes, okay. He came to CDOEO, he got help with the back rent. He's been on time, perfect ever since then. His landlord has given him a beautiful letter of recommendation to that effect. Because he applied to a nonprofit housing provider that has an appeal process, I was able to guide him through that appeal process. And happily, I learned the other day that the denial was overturned and he's been offered housing. My question is, how many people don't know about that denial process? Or how many people apply to private landlords who don't use a process like that and are losing out? Plus, I was like, wait a minute, you haven't been to court. Why do you have an eviction record? And I looked at his letter from this nonprofit agency and it's right there, eviction. So I asked, and it turns out that landlords are using these that's the word I'm looking for, consumer reporting agencies. They're national. They may or may not tailor their services by state. They don't, this one that's in use a lot in Vermont does not. It's called RealPage. They do background checks, so it's kind of one-stop shopping for a landlord. It's background check, credit check, rental history. That rental history is not court records. It is aggregated data from 20,000 reporting communities. So what had triggered that landlord was the notice to terminate, notice to vacate. A notice to me is a notice. It's an opportunity. In this case, most of the time, I would contend that tenants know when they're behind in rent, right? In this case, the guy didn't even know, right? And so I'm disturbed that people are being denied housing based on a notice to vacate being in a record. And I'm disturbed also by an eviction record of some point in time, being a lifetime barrier to housing. I think that a lot of evictions happen for non-payment. Last I knew it was about 70%. Jean Murray can correct me on that this afternoon. For non-payment only. you know, we shouldn't be penalizing people for being poor. So, yeah, that's,
Just to alert you, you have about 10 to 15 minutes left.
oh boy. Okay,
And we do have the full written testimony.
Great,
that's
thank
submitted,
you.
So you'll be able to read one as well.
And I've asked the CVOEO to submit, they have a textual analysis with suggestions, and I asked CVO to submit that as well.
so let's see, what should we prioritize? Rent increase limits, I think is the big one, yeah. This is actually a slide, I don't have the title, rent increase limits.
Sorry to interrupt you. Sadia, you have a question?
Yeah, I want her to finish and get to the rent increase limits and focus on that, but I just wanted to clarify a question. Hi, Jess. Just wondering, can you clarify to me, and I don't know if I missed this if you had said this already, the notice to vacate, is that required for people to get assistance for back payment?
Yes, I'm glad you asked that question. Yes, through the HOP program, yes.
Okay, thank you.
Yeah, the HOP program is designed to help people who are literally homeless or at risk. And one of the ways to determine at risk is the notice to vacate, 14-day notice.
And similarly, the Vermont State Housing Authority's landlord relief program, which provides that can provide the payment of some back rent, also currently requires a court docket number.
That's an excellent question. I'm glad you brought that up because it's kind of a conundrum, which is what I think may have been behind your question is, if you need the notice to get the help, then you want to receive the notice, right? But now the notice is on your record, so you don't want the notice. Like, okay, that was it. So rent increase limits. So yeah, this is a title. This is a slide I use in my workshops. Because I want to emphasize to people, I'm working with people who feel defeated, people who have lost hope, and feel it's a personal failure because they can't find housing and take care of themselves, right? So I say, why is it so hard to rent in Vermont? There's low availability and it's awfully expensive. So these statistics are, you know, just kind of speak for themselves. If somebody has to work 1.7 times full-time job to afford a market rate rent, then vast numbers of people in Vermont need subsidized housing just at a time when it's starting to get rarer and, you know, scarcer and scarcer. So I do have a specific example about that. And I'm going to read this because it's the tenant's actual testimony that he provided us. This is a Burlington resident who'd been renting in the same carriage house for 25 years. And he recently moved out. Over the years, the rent fairly and slowly went up commensurate with the increases I assumed in property tax, water, plowing, et cetera, with few improvements added by the landlord. When COVID hit, over 3 years, my rent went up an additional 60% due to, quote, all the crazy increased prices, claimed my landlord's son, who had recently taken over the financial affairs from the father. In the last 2 years, my house was broken into and my car was broken into twice in my driveway. I paid for cameras and active security lights. The landlord never once even commiserated or offered to help cover the costs of increased security. This year I had had enough. I decided to leave the home I had loved and cared for 25 years and moved out of Burlington. I gave my notice in writing legally as I was informed to do so, but the landlord responded aggressively with multiple threatening texts. And I'll note that since the tenant moved out, the units remained unoccupied. It wasn't fit to be re-rented. One of my colleagues puts it this way, if you haven't rented in Vermont in the last 5 years, you haven't rented. The market is different. The situation is different. I used to say going into workshops that if someone had resources and an advocate, I volunteer for organizations on the side and I go to viewings and help people find housing. And I used to have this idea that if we could just match everybody up with resources and an advocate, they'd find housing. That's not true anymore. So I'll just say that it's people are struggling and some limit on rent increases would hugely help the situation.
May I add to that?
Yes.
And also on our tenants helpline, we get calls every day from people whose rents are increasing not by $20 or $30, but by $200, $300, $500 with very little change to the apartment. And it's just not affordable. And the rents have already increased more than cost of living, more than incomes have increased. And then to have these really large increases that are done legally with proper notice, make these housing situations totally untenable for working families.
Yeah, I'll just point out that I'm pretty good at handling like my own emotions when I answer the hotline after doing it for a long time. But the calls that really get to me still are the older Vermonters on fixed income. You know, because other people I can say, where can you find income? How can you increase your income? We can work with that. But we have a lot of folks on fixed income without the ability and the physical, ability to continue their work.
When you get these calls, do you know of any shared housing that rather than them have the burden of such exorbitant rent of
Right.
coupling them up?
Yeah, pairing them up for both community and companionship as well, yeah. Yeah, I know. That's what I was gonna tell you. Thank you. The program that I'm most familiar with that provides a pairing up is called Home Share. Cannot speak enough good about Home Share. If you have an opportunity to support them, please do.
We do.
What's that?
do.
Oh, keep it coming. I think it's a great program. I recommend them a lot because I think they do great work at pairing. Typically, from my understanding, it's not two elders that they're putting together. It's more like someone who needs something in their home and has extra space, and someone who can provide that something, service, companionship. It can be a wide variety of things.
So I think one of my questions when you get these calls, do you offer that or ask them
Oh,
how they
100.
feel?
Yes. The situations range a lot. The person, I'll give you one example. The older person who has a voucher, so the voucher can only be used for a single unit apartment, okay? And there's limits onto what the rent can be. This person has lived his whole life in a particular community in Vermont. All his resources, his families, everything is there. I forget how old he is, but he's in his 70s. He cannot find a unit anywhere close to his community. So his voucher is running out because there's a time limit on when he can use this voucher. He's asked for extensions. He's got a lot of support help looking. He can find a 2-bedroom, not a 1-bedroom. Doesn't meet the criteria. There's a lot of places where flexibility could be opened up. I did not ask that person. He's living with a friend right now. So he's actually living with a friend right now. I don't know. It'd be an interesting thing to explore. I have older people in my family and they would not want to live with other people, I can tell you that. So I don't know how many older people.
Well, they
would
don't want to live on the street either.
Yeah, true. Oh, 5 minutes. So, should we do this or do you want to do appropriations?
Do you want to do this? I'll jump in. We're gonna go a little bit out of order just because we want to make sure that we touch on some of these other key topics: application fees, rental registry, right to counsel, and the eviction record confidentiality, which we spoke to already. But I do want to
It does sound, by the way, one of our bills has a lengthy confidentiality provision where it becomes confidential until judgment. But you do raise an interesting issue, which is you're saying somehow we ought to be able to reach back, I'm not sure how, and deal with the notice to vacate not being available to credit reporting agencies. In other words, you need a judgment. I'm just raising that issue. I'm not sure what the language would be, but I hear you. Okay.
And the one to check out to start with seems to be RealPage.
Yeah,
So I
okay.
don't know if it's a matter of contacting them and asking them.
Well, we have other state statutes that deal with reporting agencies,
Yeah.
but, okay, I'm sorry to interrupt. Go ahead. It's true, we're kind of getting to where you'll have to wrap up.
So one thing I wanted to point out is that there's a really important link between education, information, and communication, and housing sustainability and stability. So the policy is really important, and we also need the support so that people can be successful in their homes and can actually put the policy to good use. And so because of this, because of our experience working with tenants, working with landlords, we support several appropriations to increase the capacity of service providers so that whatever the policy is can be understood by both renters and landlords, and so that the support system can help people be successful. Some of these asks are part of the Vermont Community Action Partnerships, broader asks, but we're supporting funding for landlord tenant education, for financial coaches at all 5 CAP agencies around the state. As Karen was mentioning before, if someone has no way to increase their income, there's no way they can afford increasing rent. So having that financial capability, training and support is critical to success. Also, the landlord liaison positions, which were started up with one-time COVID money, proved to be really effective in forming these connections between landlords and tenants, improving communication and building relationship, the problem solver that Karen mentioned earlier. And so as part of the Vermont Community Action Partnership ask, there's $600,000 distributed among the CAP agencies for these important bridge building positions. So we just wanted to get that plug in as part of our broader testimony. And now we can move backwards for a couple minutes and touch on any of these other items that we have time for.
I think the one that we didn't get to that there was already a question about, so maybe I'll just point to the just cause eviction protections. And this does get at the difference between no cause and for cause. And so the idea here is that if a tenant is being a model tenant and doing everything right, that they can feel secure in their housing, that they won't be given a no cause termination and asked to leave unless there's specific criteria involved. This seems to be quite popular around the state. Several communities have passed local ordinances to this effect. In Burlington, it passed with a 63-37 margin, which is pretty good, I'd say. And I do have I'll try to have a short example of that. I had a call from a woman who lived in a rural part of the state. She and her husband and 4 kids rented for 14 years. They had a lease the first year, and then they were month to month after that. They put in a garden, kids were embedded in the schools, the whole 9 yards. They had their life. Good relationship with the landlord, excellent. He gave them proper notice, no cause, 60 days to find another home. And I lost touch with that family, and I gave them all the resources I could, but a family of 6 uprooted from their community and everything they knew. And I have no idea why the landlord didn't share with them why he didn't give them no cause. So it's, yeah, it seems to be very popular, and I believe it would have very good effect on folks in our community. I guess that's it. So
Thank you very
last
much.
question?
Yes.
I don't have a question. I just want to thank you for coming in and for your testimony. I sit on the board of Brock.
Oh, yes. Yes.
And
Yeah.
Tom Donahue is very complimentary of your organization.
Oh,
And they
that's nice to
do
hear.
so much.
Yeah.
Providing food.
Yeah.
And all the training, and if you need help with your income tax, and I have called upon them several times for my constituents, and they have been just amazing. So thank you for
I'm
all
going
you
to be
do.
talking to reach out staff statewide next week, and I'll be on a panel with a person from Brock.
Oh, great, thank you.
Yeah.
Thank you so much.
Thank you very much for the opportunity to be here today, and we welcome further questions.
Can I just get one
Thank
question
you.
in? As far as the sealed records portion of it, is that a blanket thing or more of a, it shouldn't be on your record if you just can't pay your rent? Like, as you said, like being poor shouldn't be criminal.
Right.
Like, do you also feel that way about criminal activity or other things, damaging of the unit? Could that be sealed as a third?
I haven't really thought about that. It's a good question. It's a really good question. I do know that criminal activity, even those records can be expunged. On the Vermont Law website, you can read up on that. They've got I refer people because I do have people who are like, this gentleman I was in a workshop with the other day, he was in his 40s. And he had a DUI and some other things from when he was 20. So he was hoping to get that off the record. So I
Yeah,
think
for
if
sure.
it's non-violent and non-sexual crime, sex registry related, that there are mechanisms for that. So I would say, yeah, if it's open to criminal records, then an eviction based on that should be open as well.
Thank you.
Thank you.
Thank you.
Our next witness, I guess, is coming to us via electronically, is Angela Zakowski, who is director of the Vermont Landlord Association and also a practitioner in the field. Angela, you want to state your name for the record and take it away?
Sure. Good morning, everyone. My name is Angela Zakowski. I am the director of the Vermont Landlords Association. We're a statewide trade organization for housing providers. I'm also a practicing attorney, and I represent housing providers in primarily eviction cases at this point. I've been doing this since 2003, so I just did that math, and I don't feel that old, but apparently that is the case these days. Thank you for the opportunity to come in to talk to the committee about all of these various housing bills. It seems to not sort of get into the specifics of individual bills that H772 has sort of pulled elements from a lot of the other bills that were on the list. And it appears to be in a proposal to sort of balance the needs of landlords and tenants. And I think that's sort of ultimately what we ask for in the legislature, is to have some balance. And what I have seen out in the field, what I'm hearing reported from landlords, is that our current system is not in balance. We have an eviction process that takes a very long period of time for housing providers who are bringing the process, for residents who are living in buildings with tenants who are not following the rules. It's a costly process, and it's creating impacts in the rental market that I think are sort of, we didn't intend. We want to have protections for renters, we want to have protections for landlords, but what we're seeing is, given the length of this process and how expensive it is, and what the financial impact is to landlords and other tenants in the property, is that it's becoming harder for renters to find places to go, because landlords are becoming more choosy as they're renting. They're spending more time screening. They're not taking risks on applicants because they know there is such a long process if there's a problem at the end. So one of the asks of the housing provider community is to have a faster and more efficient process for removing tenants if there's a problem, whether it's unpaid rent or some sort of lease violation, whether it's drugs, whether it's damaging the unit, whether it's noise violations, basically creating a not tenable living environment for other residents in a building or the neighbors to a rental property. Housing providers are asking for assistance in dealing with those folks after an eviction has happened. So what we're currently seeing is that a landlord can go through an eviction process, have a tenant removed from a property, and then have no way to prevent that person from coming back onto the property after the eviction is over. This is sort of what I have been referring to as the Decker Towers problem, which is that landlord was evicting tenants. They were being removed by the sheriff, then they were coming back to the property, moving in with their neighbor, continuing with the same chaos that got them evicted the first time. Then the next household had to be evicted out of the property, because there is no good mechanism under the law currently for the housing provider to prevent that person who's been lawfully evicted through a court order from coming back to the property to create more chaos and more problems. So those are sort of two asks of the landlord community, housing provider community. Couple pieces of information that I wanted to share. We hear a lot about vacancy rates in Vermont, low vacancy rates. For the first time in December, we saw vacancy rates above 4%. So there's been a substantial increase in the vacancy rate, which means sort of an easing of the market for renters. And it also means that I think we're starting to see some of the impacts of all of the new units coming online, which is good, right? We're been talking about having housing crisis, not enough units for people to go to live in. And so that pretty significant jump in that vacancy rate shows that these things are working. Specifically, I wanted to provide some comments about the rent control provisions that are in H772. Rent control is a very challenging regulation for housing providers. It has not worked well in jurisdictions where it has been imposed, and it doesn't help with housing issues. It suppresses investment, it discourages investment in rental properties. It discourages people from improving rental properties. We generally see a degradation in the quality of rental properties in jurisdictions where rent control has been imposed, because it limits the amount of money that the landlord has available to them to reinvest into that property. This proposal has caps in it, reasonable. New owners are capped by 3%. We've seen double-digit property tax increases over the last 2 or 3 years. And so those numbers don't match. And realistically, for the most part, rents are increased to match increase in operating expenses. We will see properties where an owner has sort of stabilized. Maybe they don't have a mortgage, they've owned the property for long term, and they keep their rents relatively low, maybe to the detriment of those tenants, because when that property gets sold, many times those tenants see a large increase because the new owner coming in, whether it's an investor or whether it's a mom and pop or whether it's somebody coming in to buy their first property that happens to be a duplex or a triplex, we see rents having to be adjusted so folks can meet their obligations. So I think generally, I had put together a sort of interesting look at what eviction processes look like in other states. And this had never, I don't think, had been done before. And one of the things that I found was that it's sort of hard to compare these apples to apples because most other states have some form of a summary eviction process that does not necessarily look like what we have here in Vermont. So what is consistent across many jurisdictions, including Vermont, is that evictions tend to be a two-step process, which is step one, the tenant is sent a termination notice for some reason. So, landlord says this is what the issue is, and the various jurisdictions have requirements for how long those have to be. So on the left here, I've listed out what those various notices are. This column here for Vermont is what we currently have under our current law. I pulled in what 772 is proposing to change these dates to, and then it sort of tracks through other jurisdictions. So we have New Hampshire, which has a 7-day non-payment notice, 30-day breach notice, and a 7-day serious violations notice. We have Maine, which has a 7-day non-payment notice wasn't clear. So some of these I was trying to pull the best I can. So if there's blanks, it's because I couldn't find the information out available online. So I pulled all of this information for Maine, New Hampshire, outside of New York City, because New York City sort of has its own system that it uses that's quite a bit different. I pulled New Jersey, I pulled Massachusetts, I pulled Washington State, and I pulled California, because these are many jurisdictions that tenant advocates talk about when they're trying to compare Vermont and systems. So I looked at notice timeframes, and I provided this electronically so you can look at it. It's a big spreadsheet. It doesn't print well, so I apologize for that. In all of these jurisdictions, after the termination notice is sent, the notice is enforced in court. So in none of these jurisdictions is there no court action. So there's always a court action of some form. Some states have housing courts where these are handled. But I wanted to look to see, how are we comparing with other states in terms of length of time, what the processes are. And what I have found is that all the way at the bottom, there's a court process timing. So we're seeing Vermont is roughly on average 4 to 6 months for a non-jury type case. We can expect 6 to 12 months if the tenant asks for a jury trial.
Angela,
Yes.
Angela, this, I understand what you're about to do. Are you talking time from filing of the ejectment motion to judgment or effective ejectment, or what's the beginning and end that you're talking about?
So when I was calculating court process timing, I was calculating from court filing date to removal of tenant
Okay,
in that process. So sort of start to finish from the court. It does not include the notice timeframes. I left that off
Yeah.
and focused specifically on how long the court process took itself. So Vermont, we're seeing, 4 to 6 months on average. The 772 proposal would make that somewhere between 40 and 70-ish days, depending on whether it was a non-payment case or a substantial violation case. And then we see in a lot of these other jurisdictions, 30 to 45 days, 1 month to several months, depending on court schedule, 2 months, 1 to 2 months, 3 weeks. That's Washington State, 30 to 45 days. So even with this proposal, H772, we're still sort of at the longer end of all of these other jurisdictions and how they handle eviction cases and court process. So this is available. I didn't want to spend a huge amount of time on it, but I just wanted to explain sort of how it's laid out and what the information is in there for everybody, because I think it's helpful to see what other places are doing.
Angela,
Yes.
I guess it's my job to ask difficult questions here. One of the 2 questions that I'm sure are in people's minds. One is, okay, let's assume for a moment that our overall time process is too long.
Yep.
What we've just heard is compelling testimony so everything has to be shortened to get a shorter time period overall. What we've just heard is compelling testimony that shortening an answer period to a week or less, 5 days in some of the bills, is just for many tenants not feasible for them to make, that we'd get defaults, unintended defaults. But yet we want to make it shorter. Any
Right.
thoughts as to how one bridges the gap between these 2 realities?
So I think I have, yes, I do. I think for every civil case that's filed in the state of Vermont, this is broader than landlord-tenant. One of the pieces of paper that I am required to include in with the packet that the tenants get served on is a blank answer form.
A blank answer form.
Blank answer form. So tenants are provided with the packet that they're served on by the sheriff everything they need to be able to respond to the paperwork. And in fact, I can show the committee what a blank answer form looks like. There is not sort of a specific format. So this is what the tenants receive in their packet with the court documents. It is pretty straightforward. And realistically, all tenants have to do to not be defaulted is file even just a notice of appearance with the court saying, I'm here, I want to participate in this case. That is enough. There is no magic words that have to be said. There is no special format. In fact, you could argue the special format is right here. This is all that needs to be filed. And this is in the packet that tenants are served with as a part of an eviction.
Yes, Debbie.
I have seen a lot less defaults in landlord-tenant cases since this form has been required to be included. I believe that went into effect February of 2022 or maybe 2023. They start to blur together after a little bit. So this has been out there for a while, and I regularly see tenants send these back. Sometimes they use other forms, sometimes they have contacted Legal Services Vermont or Vermont Legal Aid, and those forms come in, and sometimes they handwrite out things that they file with the court. But I've definitely seen fewer defaults since this form has been provided in the packet.
Debbie, did you have a question?
Well, I was just gonna say there's also instructions on how to fill it out that are included with the answer form.
Correct. And the summons, which is sort of the legal document that gets included that says, here's what you have to do and here's the timing for the answer, provides the address and contact information for the court, and it provides the address and contact information for the landlord's attorney or the landlord if they're representing themselves. So it's all right there in pretty large font. There's certain things that are bolded, like it's a form that the judiciary uses that we all have incorporated that lays out all of this information in very plain English. It's not legalese at all. So I think, what we have seen, or I have seen, and I think one of the advantages of having been a practitioner for so long is you sort of see these cycles of things. And a number of years ago, housing providers came to the legislature and said, we're having this problem where after an eviction, tenants are just leaving all of their personal property in the rental unit, and there's not clear guidance under the law what we're supposed to do with this personal property. So we came to the legislature and requested a change, allow us to get rid of property that's left behind. And many of the same arguments that I'm hearing today from tenant advocates happened at that time. Tenants are going to lose all of their personal property. It's going to be chaos. They don't have enough time to get their stuff out. They don't, it's everything that could go wrong. What I can report to the legislature is maybe the first couple of evictions after this law went into effect, we had a few of those hiccups where the information hadn't gotten out to tenants that they needed to get their things out of rental properties at the end of an eviction. But in the time since, tenants are removing their property from rental properties after they get served with a writ of possession because they know it doesn't have to be stored. So what we see is that people are able to conform to changes when they are aware of them, but that the changes don't necessarily make it worse. They just change the expectations. And so when people understand what those expectations are, they're able to navigate and work within those systems.
Under current law, there are notice provisions, are there not? In other words, you have to tell the tenant, you got to come get your stuff by such and such a date.
That is true if you're treating the property as abandoned. So at the end of an eviction, there is not a notice provision. It is when you get possession of the property, and if a certain number of days have passed, you're not obligated to store that property. Most landlords I work with are willing to work with tenants about removal as long as there's a plan to have things removed post eviction. So
Angela, can I ask a question about your members and the landlords that you work with?
absolutely.
If you have data for this, great, and it kind of goes into like the rental registry idea, but like when you work with landlords, would you say you work with a majority of very large corporations or more mom and pop, small, somebody has a house, a unit, and they want to help, they want to be a housing provider?
I work with both, all. I have in sort of wearing both hats, both
Yeah.
in the association and also through the law firm. I have a wide range of owners that I work with, and I think what I have noticed among the housing provider community is that regardless of whether they're a big company or a big corporation or a small mom and pop, or maybe they just have a handful of properties, they're in the business of renting units. They're not in the business of doing evictions. They're in the business of renting units, and they also understand that they're renting to humans. So they want to do the right thing. They try to do the right thing. They try to work with people. They don't always have that coming back to them. And realistically, an eviction is the only tool they have for dealing with tenants that are causing problems or not paying the rent. Like this is the tool that they have. And in many cases, they're still attempting to work with the tenant through the court eviction process to see if there's a solution or finding avenues for tenants to make payments to get caught up. So it's not, and I see this across the board, it's not something that just small landlords do or just large landlords or property managers do. It's sort of across the board.
Angela, you have about 5 minutes. If
Okay.
you want to emphasize anything in particular.
I think there's some very great provisions in 772. I think all of the ones that are relating to streamlining this process for non-payment situations and lease violation situations are going to be very beneficial, not only for helping with housing, but also in terms of protecting other tenants who are living in those buildings with these folks who aren't following the rules, and will, I think, create a situation where landlords would be more willing to rent to folks who maybe don't quite meet their rental criteria or really on the cusp. I was giving a presentation to a room full of landlords a couple of weeks ago, and I asked the question. I said, if you knew you could have somebody out of your property in 60 days or less if there was a problem, would you be more willing to take a risk or take chances? And the answer across the board unanimously was yes.
Any questions of Angela? We may have additional questions, and I'll make sure that your side-by-side analysis is distributed. It is partly just some people have it, I think, but
Certainly, and I'm always more than willing to come back and answer other questions or talk more specifics about process and their proposals as the committee develops them.
we have, I think, we may need that, and also witnesses. We've asked witnesses to provide us detail. And I know you have provided detailed proposals. Any last questions? In the last 2 minutes, I can't help myself but asking you another question you might find difficult. So we've had, we don't have a lot of data. So we have to make decisions on the basis of stories.
Mm-hmm.
And it's hard to know who to believe sometimes because we get different stories. One set of stories on rent increases is that, well, they're due because of increased costs, increased taxes, investment in the property, other legitimate costs. Then we have stories of no, landlords just bumping the rent up because they think they can get a lot more in a rising market. And so they're throwing out less tenants who are able to pay less in favor of tenants who can pay more. How would you feel about, do you think it's possible to bridge those two situations by limiting rent increases to costs, legitimate costs?
I don't think so. And here is my analogy for you on this. So currently, we do have a type of rental property in the state of Vermont that is subject to rent control, and that is mobile home parks.
Right.
And mobile home parks have had that for a number of years. And they do have a mechanism for asking for increases for capital improvements that would make a larger rent increase than what's permitted under the statute. And I think, what we have seen is we have seen non-investment into these parks. In fact, when COVID money came through with money available for mobile home park improvements, that money went quickly because park owners had access to funds to be able to make these improvements. Of course, there's costly improvements that need to happen in mobile home parks, septic, water, roads, like they're not things that are inexpensive. We've also seen no new parks come online. We've seen, parks sort of shuttering down. We've seen some transition to co-ops where the tenants now are owner of the park. But it has really sort of stalled out that particular type of housing. And I think to the detriment of what is generally a very affordable type of housing for folks.
Yes, we have a question. Go ahead.
Can I ask generally, what would be like I guess it's the mean, not the average, but the mean, like generally, how long do landlords own a property that they are renting in your population that you would
I see everything from the person who's owned a property for 50 years to owners who own for a few years and then sell, or are constantly moving from one property to the next. So it's a very different market, and it depends on the person's personal sort of circumstances and why they're getting into rental properties. There is not a one size fits all model. I sort of have seen it all.
Okay, so, and does it change by region by any chance?
I don't
Do you see a
think
tendency in urban centers versus other more rural areas?
I don't think so. I mean, I will say I see more, I inherited this from my mom and dad type landlords in maybe some of the rural areas than I do in sort of more of the urban areas. But overall, no, I don't. I have not noticed any trends in ownership types around the state.
And do you think that a regional or municipal approach that's like some municipalities that have wanted, for instance, just cause protections, do you see any path for those kinds of, like, if a municipality wants to be able to ensure, well, the rules here are going to be different because the pressures are different in this place, the tensions are different in this place, we should have the right to do that?
I think what I've seen is that the tensions and the pressures are the same around the state. And they don't change by municipality or jurisdiction. And I think what we need is a statewide housing policy. So we need a statewide system that is consistent throughout the state, that people understand, that's easy to follow, and that isn't piecemeal from here to there, where the rules change depending on where you live. So a landlord in Bennington and a tenant in Bennington struggle with the same things as somebody in St. Johnsbury or Essex County or Burlington. It it may look slightly different, but they're all the same issues.
Angela, thank you so much.
Yes.
Really
Thank you.
appreciate it.
Thank you for having me.
Sure. What we're gonna do now for the next half hour, have a seat, Sophie, is transition to consideration of H 548. H 548 is an act relating to adding a mediator position and possibly an attorney position to the Office of the Vermont Labor Relations Board. What we're doing now is, remember, we had a markup session in which we asked our counsel to add certain provisions and redraft it. He's done that and will share it with us and we can discuss it. And we have it on our agenda for a possible vote. And our clerk has stepped out on us.
We can find her.
We can find Mary if we do that. Okay. Good morning.
Good morning, Sophie Zadatny for the Office of Legislative Counsel. The amendment is up on your website, but I did print out highlighted copy showing the change. Great. As it's quite short, I mean, I'm happy to put it up on the screen, but you want me to do that?
Maybe it would be good to put it up on.
Okay.
Oh, you didn't have to. I could have come.
Things start to freeze.
Right, so H 548 is to add a mediator to the Office of the Labor Relations Board. Pull up and highlighted one, but anyway. So this adds in, there was discussion last time around the language essentially limiting it to having a mediator work when the parties reach an impasse during collective bargaining. And our statutes, our labor relations statutes, mandate mediation as a necessary step in the process. But mediators are not required, but are often used also for grievances and unfair labor practices. So subsection 2 here provides that if the mediator has capacity, the mediator may provide free mediation services to public and private sector collective bargaining units and employers on grievances and unfair labor practice charges as well. The other, and then in subsection 3, that's at the top of page 2, there was a concern around the mediation process as a confidential one, and it's really important for the integrity of a successful mediation process that both sides really trust the mediator and that the mediator is keeping the information that the mediator learns through mediation confidential. So if the mediator is located in the Labor Relations Board, there's a concern that information not be transmitted between the mediator and then the board members or the other staff members who, are ultimately deciding if there's a dispute and it goes to a hearing, so that that information be kept separate. So what this subsection does is requires the board to develop policies and procedures to ensure that all confidential mediation information is maintained separately and insulated from access by members of the board or other members of the State Labor Relations Board, so as to protect the integrity of the mediation process. And then finally, in section 2, this was to add in a classified staff attorney position. So this just provides for that. The position of a full-time permanent classified staff attorney is created in the office of the Vermont Labor Relations Board. And then it increases the amount for the salary and benefits for both positions from 115,000 up to 250,000 as the appropriation asks.
Questions of Sophie? So just to discuss process for a minute. What I'm going to do is ask in a minute for any discussion, any thoughts on this? And then we'll go to a vote.
Do you want me to go find Mary?
Yeah, well, I think maybe that's underway.
Oh,
I think she's trying. And what we'll do, just to clarify, if we were to vote it affirmatively, because this contains an appropriation, the person who would be the reporter would simply stand up. You remember when I stood up on the floor and said, I'd like the committee to be relieved of bill and then assigned to somebody else? She'd get up and say, the committee has passed it out and would like it to be relieved of it, and it'd go to appropriations. In other words, it doesn't go to the floor for a final vote until it goes through appropriation.
The speaker just did that.
Happen
unilaterally.
automatically? Yeah.
Speaker just does that unilaterally.
You know, I asked
Nobody's
the
ever stood up.
speaker, and she said, you're right, she can do it, I
Yeah.
think, because to appropriations, she is the only committee.
yeah, they're like.
If
referred
it goes
for
to another
money.
committee, it would have to stand up. You're
Yeah.
right. If it goes to appropriations, it's just, she can do it. She'll just get up and say that. So, discussion. Yes, Debbie.
Oh, so this amount is just for people.
Right, the mediator and the attorney.
We don't have a place to do the mediation. Do we have that?
The mediation would happen offsite.
At the businesses or at the institution that they'll provide the space. That's generally what the
Okay.
feds used to do. That's what.
Yeah, so
that's
I
what-
was gonna say the original bill as introduced on the floor had language about placement. But I think through our conversation and from testimony, it seemed that that wasn't necessary.
So they don't have any home office?
They do.
They do.
They do. The mediation,
I know the mediation stuff takes.
yeah, but they have an office.
They said
An
they have
office where?
space.
They have an,
I think it's close by.
somewhere here.
Yes, it's right down next to the Lincoln, it's right down there on Bay Street.
Well,
Thoughts on this bill?
well, I think, yeah, I support it. I think I'm done.
We've heard how backed up the labor board is. They only have 2 people, I think, working, and so I would be in favor of this. Anything to help move things along instead of backed up I think would be beneficial.
I also support the bill for several reasons. We have, in the last several years, I think everybody's been struggling with the backup at the labor board. And as I think I mentioned, we actually have on our wall some bills which would take things out of the labor board and allow them to be done by the parties, largely because people are despairing of how long things take at the labor board. I thought that the mediator the mediator is to try to backfill it really doesn't address the main issue. It backfills the loss of the federal mediator. Probably one of many areas where we are going to have to pick up the loss of the federal role. And the extra attorney would try to address the backlog. So I support the bill. Debbie?
Is it ever gonna be addressed, like if we get caught up and we find we don't need that, you know, an extra person?
Yeah, that's so.
Like, are we ever gonna look at it again or, are, you know what I'm saying?
Depends if we're enough.
I know.
I think that, first of all, I would guess that is a highly unlikely scenario, given the terrific backlog that they have. But I think that one of the functions that I'm hearing a lot about is the need for the legislature to examine the budget of agencies that they're responsible for, to make sure and to ask them, what are you doing with this program? What are you doing with that program? Because it is true, not so much in the small bureaucracies or tiny bureaucracies like the LAOB or the Labor Relations Board, you know, just a few people, but in some of the huge agencies, I know that, for example, human rights, what's it, HR?
Human rights.
Teresa Wood's committee is
Human services.
Human Services. The Human Services, they have found millions of dollars. So that is part of our oversight.
Okay.
Yes.
And I think if I'm not mistaken, the bill is appropriating for 1 year. Is it base funding or is there anything in the bill that clarifies whether this is going to be in perpetuity?
It does say permanent position.
Yeah. If there's a permanent position, it wouldn't be a limited service position. Let me tell you, permanent, I can tell you from my own experience on the Appropriations Committee, is that base funding, which is what it's called, is very hard to come by.
Right.
And I mean, this year, I think one-time funding is going to be hard to come by.
Yeah.
But they make that decision.
So do we, if we, is it likely that we will be asked to prioritize one position over another, or is that unlikely? Are we
I think
likely to just
eventually,
get a no straight up?
eventually we will have input.
Okay.
Somewhat strangely, the budget letter that I sent you all that's due the 20th, and we're gonna have to get VHCB in here. We've got DHCDs that come in. Just, you know, and LAOB, I asked them to submit a letter to us. I have been told yesterday by the chair of the Budget Committee that we really ought to focus on agencies and what's in their budget, not so much what our bills that we are passing out do, that we will have a chance to do that later.
So the fact that this is not an agency request. Okay.
I will be alerting the chair about this. I will alert the chair for each one of our bills, what the possibility is of an expense to the general fund.
And can you remind us again, the total?
250.
Got it.
Further discussion?
I move
guess-
that we adopt draft number 2.1 of H 548.
Second. Okay, we have a second.
Second.
We got my second.
All right. Madam Clerk. Absent any further discussion? Would you please call the roll? Boy, that was.
Chip shake.
Jeez, I'm telling you.
Representative Bartley,
Yes.
Representative Burrows is absent. Representative Charlton,
Yes.
Representative Dodge,
Yes.
Representative Dalton,
Yes.
Representative Howard votes yes. Representative Krasnow,
Yes.
Representative Lamont
Saudia.
Yes.
Representative Parsons,
No.
Representative Pezzo,
Yes.
Representative Mahali,
Yes.
Nine one one.
911.
Okay,
911.
you should be the reporter of the bill.
Yeah,
Okay, at the moment,
right.
well.
So
but you-
remember
you-
what happens?
I think you simply write an email to the clerk.
Nigel.
Nigel.
Left us a little
Oh,
reminder
nice.
because we talked about it. so
Right.
much.
So, I will, yeah, do the rules,
Okay,
and then we'll wait and then, see what happens.
well, Jill will, we'll
Right.
get Jill to refer it to. Okay,
Thanks, Sophie.
Thank you.
We voted a bill out.
The second one.
Working too.
Oh, right, sorry.
Yes. My, my personal bill.
Right, oh,
We're still live.
At this point, I think unless there's any questions or concerns, we're going to adjourn for lunch and we're going to return at 1:00 for committee discussion on 459, which relates to parental and family leave. And then it's not set for vote. And then we're going to have return to 772, that is to landlord tenant for more testimony.